So dear students, I welcome you once again to this class on business law. In this video, we will try to understand what is an offer. So an offer can also be called as a proposal. So according to the section 2 subsection A of the Indian Contract Act 1872, when one person signifies his willingness to another to do or to abstain from doing anything with a view to obtaining the assent of the other person to such act or abstinence, he is said to make a proposal. So the first thing here to understand is that one person who is the offerer or the promiser, when he signifies his willingness to do something or to abstain from doing something to another person who may be the promisee or the offeree, so with a view to obtain the assent or the consent of the promisee, that is called a proposal or an offer. So how is an offer made? Okay, we can understand that there are two kinds in which the offer can be made. One is through words and another one is through contact. So first one, when we see, it is also called as an express offer because it is being expressed through words. It can be expressed through written or oral communication. So written can be through letters or emails, etc. And oral communication may be through over telephone or in person. So for example, Mr. Somu proposes by letter to sell his house to Mr. Ramu for rupees 50 lakh. So here there is a offer which is made by words, which is expressed through a letter. And the second one is by contact, which is also called implied offer. So an implied offer is made through positive acts or signs by the promiser. For example, in the case of a passenger boarding a public transportation bus, the passenger enters the bus with an intention to become a passenger by paying the ticket. So there is a contract between the passenger and the public transportation department. So wherein the passenger has to pay ticket and pay for the ticket and travel in that public transportation bus. So the next thing what we're going to see is the essential requirements of a valid offer. So these are the essential elements that are required in a valid offer. So first one is the offer must be communicated to the other party. So as we discussed in the earlier slide, an offer can be communicated through words or by implications. So definitely there should be a communication which should be established between the promiser and the promisee. So a communication is very important when it comes to a valid offer. So for example, if the promiser thinks in mind that he wants to get into a contract with another promisee, but he does not communicate it to the promisee, so that does not end up in a valid contract. So that is not a valid offer. The second one is the offer must be made with a view to obtain the consent of the offeree or the promisee. So always there should be intention from the point of view of the promiser to obtain the consent or the assent of the promisee. And the third one is the terms of the offer must be definite and certain. So whatever is listed down in the offer should be definite and certain. It should not be vague. There should be proper information. There should be apt information, timely information. So it should not be vague or uncertain. Fourth point is an offer must be capable of creating a legal relationship. So every offer that needs to end up in end up as a valid contract needs to be uh, created with the intention to create legal relationship. So that means it can be enforceable by law. So that is the meaning of legal relationship here. Fifth point is must be express or implied from the circumstances. So as we saw in the first point, communication. So an offer can be expressed or implied from the particular circumstances. Sixth point is an offer may be conditional. So there can be condition from the point of an promisor to the promisee, where the promisee has to fulfill that condition. Seventh one is uh, a mere statement of intention to do something is not an offer. So there should be the essential requirements such as proper communication of the offer, intention to create legal relationship, intention to obtain the consent of the offeree, and the terms should be definite and certain. Okay, all these essential requirements need to be there for a valid offer. So mere statement of intention cannot become an offer. So next thing is tender. So we can also call tender as an offer. So it is actually a response to the invitation to offer. Uh, so there are two kinds of tenders. So we'll be able to understand it better through these two types. So first one is a definite offer and a second one is a standing offer. So when you talk about the definite offer to supply goods or services or to do something, so when we see an example, A invites tenders for the supply of 1 lakh bricks. So A wants 1 lakh bricks at a point of time, and he requests for tenders. So at this point of time, there is a general request to the public, and three people who are X, Y, and Z submits their tenders. So three people have responded with their tenders. So they have offered to A to supply him bricks. So in this point of time, A accepts X's tender and he has rejected the other two tenders. So he has accepted this offer from X. So now there is a binding contract between A and X. Okay, so this is a one-time offer. So it's a definite offer. The second one is standing offer. That is for a long period of time. So for example, we can say the same kind of example. We can say that A invites tenders for the supply of bricks each month for 12 months in the coming year, which is 2021. So every month he wants bricks, but the number of bricks is not mentioned at the moment. So that may vary from time to time, from month to month. So he may communicate it to the supplier. So he wants tenders mentioning these criterias. So in this scenario, maybe again X, Y, and Z may submit tenders stating that they will be able to supply bricks for the coming 12 months in 2021. And so finally, we will see what is revocation of an offer. So revocation means withdrawing or cancelling the offer. So an offer can be revoked or withdrawn or cancelled at any point of time just before the offer gets accepted by the promisee. So there are two ways in which offer gets revoked, by giving notice of revocation or by lapse of time. So by giving notice of revocation means an offerer, once he states his offer to the offeree, and the offeree is yet to accept his offer. No, he is taking some time to accept his offer. Within that time, if the offerer wants to cancel or revoke the offer, he may do so by giving notice of revocation to the offeree. By that case, the offer gets cancelled or revoked. And the second kind, when we see an offer when made, will have a time period for the offeree to accept the offer, maybe 3 days, maybe 5 days time, maybe 10 days time, maybe 1 month time. So uh, an offer may be made, mentioning that it has 1 month of time for the offeree to accept the offer. So by that time, if the offeree does not accept the offer, and if the time lapses, the offer automatically gets revoked. So these are the two ways in which an offer may be revoked. So thank you, students, for listening. Thank you.